case, item 10 and 11. They want to say that Dr. Kapoor Pandey, correspondence, page.
Yes, okay. It's me just at the moment. Let me just brief. Both these petitions are arising out of the same ECIR. Yeah, that's same ECIR. That's right. About two different accused persons. That's correct. That's only common order. Yes. Challenged by the accused person separately. That's correct. That's yes. Just, may just leave everything for the moment. Let me in 5-7 minutes tell your lordships what the issue is. The issue is a purely legal issue. Yes. Whereas on the 31st of August 2023, whereas the Enforcement Directorate issued a summons knowing full well that the person against whom they've issued the summons is in Australia. On the 1st of September, they issue a summons. They know that he is in Australia. And whereas they ask someone to the present petitioners. That's correct. They ask him to appear on 2nd. On the 2nd. Whereas he is a citizen of Vanuatu. And whereas the Australian authorities detain him at immigration. Right? So he can't appear in any case before the ED on the 2nd. Then they issue him a summons that he should appear on the 4th. On the 2nd itself, that you appear on the 4th. Can't appear on the 4th. Thereafter, Malaj, have you informed the authorities that I am in Australia and this is the problem? They know about it. They admit it. It's an admitted position. What I'm telling you are admitted positions. Yes. So, Malaj, he can't possibly come. Thereafter, they move Malaj under Section 70 of the Code of Criminal Procedure and pass an order against me under Section 70. Now, Malaj, the question that arises for your Lordship's consideration is, one, when a summons is issued, and these are poor questions of fact, law, Malaj, we're not going to go into fact because this is not a quashing petition. The question for your Lordship's decision is that if a summons is issued by the ED, it can be issued to an accused or it can be issued to any other person. The PMLA prescribes procedures that have to be followed if a person is issued a summons who is not an accused and a person who is issued a summons who is an accused. And those procedures are set out in PMLA itself. I will demonstrate to your Lordships, that they have not followed those procedures because PMLA is a code in itself. The Code of Criminal Procedure does not apply and the whole proceedings are null and void. This is the only question of law that is to be argued. Now, just a bit about the PMLA. The PMLA deals with two kinds of offences. One, what is called a predicate offence. That is, supposing I cheat somebody, then if it is part of the schedule of the PMLA, it is a predicate offence. And on the basis of that, the Enforcement Directorate can lodge what is called an ECIR and proceed under this Act. Now, the proceeds from the predicate offence, for example, you cheat somebody 10 lakhs of rupees, those become proceeds of crime. And whereas if you take those proceeds of crime and seek legitimation of those proceeds of crime by putting it in a bank and something like that, then you are trying to show something that is illegal as legal. And therefore, that is money laundering. It's like you put dirty clothes in a washing machine and they come out clean. So your dirty money comes out clean by by your taking steps to ensure that it is legitimate money. So that is money laundering. So there are original FIRs filed in this case where I was not shown as an accused. That is, neither of us was shown as an accused. Well, then these proceedings took place and an ECIR was lodged.
In which ECIR your name appears?
The present ECIR.
First, second, third. In which ECIR?
No, there is no first. That's a summons, Malad.
There is.
We are not at the moment, Malad, at that. Now, Malad, even a complaint has been filed. So that's a separate issue. I am only, Malad, on the procedure adopted under the code. That's the only. That's a pure question of law, Malad, and nothing to do with the facts. Because as and when the facts come, Malad, we'll file a quashing petition or whatever. That's a separate matter, Malad. At the moment, I am residing in Dubai, Malad. And the case essentially is, Malad, that I run what is called a Mahadev book or a Mahadev app platform. Now, on the basis of that platform, there are certain panel operators. In other words, Malad, people can play games. They can play cricket, they can tennis, or they can play poker, they say. So people who are panel operators in India seek access to my platform and they get players to play that game. And the allegation against me is that when the players play that game, that is gambling. So a predicate offense has been committed. Correct? And the proceeds that emerge from playing that game, or which a certain portion allegedly is attributed to me, is money laundering.
Yes.
Right? So this is essentially the case in a nutshell. We can go through it, but that's not relevant for our purposes.
Yes.
So the enforcement directorate can then, in the course of their investigation, with respect to not proceeds of crime, because that's investigated by the investigating agency, they are only dealing with money laundering. So when they are entitled to seek summons, proceed against an individual, ask him to appear. And that is under section 50 of the PMLA, where you can summon anybody. Now the section 50 doesn't make a distinction between an accused and a person who is not an accused. It makes no distinction. So Manoj, when a person is summoned under section 50, he doesn't know in what capacity he is being summoned. Right, Manoj? Then, if he doesn't answer the summons, then the consequences of his not answering the summons, if he is not an accused, are set out in section 63 of PMLA. The consequences of an accused not answering the summons is set out under section 59. Correct, Manoj? PMLA is a complete code in itself. So if the consequences of non-compliance of summons are set out in the Act and the procedure to be adopted for non-compliance is set out in the Act, there is no need to go to the Code of Criminal Procedure. And therefore, these all proceedings are illegal. This is the short point. Now, let's kindly come to section 50 of PMLA. Yes. The title is Powers of Authorities regarding summons, production of documents, and to give evidence. The director shall, for the purposes of section 30, just mark that, have the same powers that are vested in a civil court under the Code of Civil Procedure while trying a suit in respect to the following matters, namely, discovery and inspection, enforcing an attendance of any person, including any officer of a reporting entity, and examining him on oath. Kindly mark the expression reporting entity. Compelling the production of records, receiving evidence on affidavits, issuing commissions for examination of witnesses and documents, and any other matter which may be prescribed. Now, what is section 13? Let's go to section 13. So 50 subsection 1 deals with section 13. Section 13 says powers of director to impose fine. the director may either on his own motion or on an application made by any authority, officer or person, make such inquiry or cause such inquiry to be made as he thinks fit to be necessary with regard to the obligations of the reporting authority under this chapter. There was a mention of reporting authority under 13, under section 50 subsection 1. So these proceedings under 50 subsection 1 deal with reporting authority, correct? Now, if at any stage of inquiry or any other proceeding before him, the director, having regard to the nature and complexity of the case, is of opinion that it is necessary to do so, he may direct the concerned reporting authority to get its records, as may be specified, audited by an accountant from amongst a panel of accountants maintained by the central government for this purpose. And the expenses of and incidental to any audit under subsection 1A shall be borne by the central government. If the director, in the course of any inquiry, finds that a reporting authority or its designated director on the board or any of its employees has failed to comply with the obligations under this chapter, then without prejudice to any other action that may be taken under any other provisions of this Act, he may issue a warning, direct the reporting authority or its designated director on the board or any of its employees to comply with the instructions, direct such reporting authority or its designated director on the board or any of its employees to send reports at such interval as may be prescribed by an order impose a monetary penalty. So section 13 is directed towards a reporting authority, and section 50 subsection 1 deals with issuing summons to a reporting authority, right? Now kindly see the definition of reporting authority that's set out here, and you will find that it's at 2 subsection WA, reporting entity. Reporting entity means a banking company, financial institution, intermediary, or a person carrying on a designated business or profession. Right, Bharat? Why is section 13 like that? Because if you're going to launder money, you will have to do it either through a broker or a businessman, a professional dealing with money, or through the bank. So section 13 says that if we get suspicion that somebody who has proceeds of crime and is laundering it, then the reporting authority may be called and asked to produce evidence, produce the documents, produce the bank statement, produce the ledger entry, right? So the purpose of the 50 subsection 1 is to send a summons to a member of a reporting entity and seek evidence in that regard. So that's the scheme of section 50 subsection 1. Now let's go back to section 50. Then the subsection 50 subsection 2. The director, additional director, joint director, deputy director, or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of any investigation or proceeding under this Act. Now, this is beyond reporting authority. The ED can ask anybody, any person, right, for the purposes of an investigation or proceeding under this Act. Now, when I argued the case in Vijay Madanlal Chaudhary, I indicated that the expression here is investigation. Investigation is an expression relates to criminal investigation, and therefore this expression must be so interpreted. The court rejected that argument.
Any investigation or proceeding under the same.
Correct. So the court said the investigation is also a proceeding. The court rejected my argument. Normally, that matter is before a special bench on the 18th of this month, the review of that matter, but that's another matter. All the persons so summoned shall be bound to attend in person or through authorized agents, as such officer may direct, and shall be bound to state the truth upon any subject respecting which they are examined, or make statements and produce such documents as may be required. So, this is for everybody, not the reporting authority. Then every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding under section within the meaning of 193. So, if I do not state the truth, then I am liable to be prosecuted. So, because it's not an investigation, because I am not an accused, I am still bound to state the truth. I don't know in what capacity I am being called, but this argument of mine that there's a distinction between investigation and inquiry is rejected by Supreme Court. Correct, Mullahs? So therefore, section 50, they can summon anybody to appear and give evidence and to make a statement which must be truthful. Right? Now, this is the scheme of section 50. So a summons was issued to me under section 50. Not as a reporting authority, but under 52. 50 subsection 2. Right, brothers? And I did not appear. Let's assume that the summons have been served and I did not appear. I'll assume that for a moment. My argument is going to be that summons is bad in law, but that's just another matter. Kindly now see 63. May I read 63? Yes. Any person willfully and maliciously giving false information and so causing an arrest or a search to be made under this Act shall on conviction be liable for imprisonment for a term which may extend to 2 years or with fine which may extend to 50,000 rupees or both. So this is when you make a statement which is false, this is the consequence. Now see 2. If any person skip A and B, Malats, because A deals with being legally bound to state the truth and he refuses to answer questions. So that stage as terrorism. And refuses to sign any statement, that stage as terrorism. C applies. To whom a summon is issued under section 50. Lordship sees that? Either to attend to give evidence or produce books of account or other documents at a certain place and time, omits to attend or produce books of account or documents at the place or time, he shall pay by way of penalty a sum which shall be not less than 500 rupees, but which may extend to 10,000 rupees for each such default of failure. So, if I don't appear, willfully don't appear, then this is the consequence. Then subsection 3. No order under this section shall be passed by an authority referred to in subsection 2 unless the person on whom the penalty is proposed to be imposed is given an opportunity of being heard in the matter by such authority. That's subsection 2. That stage as a terrorism. Then subsection 3, this is 4 now. Notwithstanding anything contained in clause C. Clause C is to whom a summon is issued, which I read to your lordship. Notwithstanding anything contained in clause C of subsection 2, a person who intentionally disobeys any direction issued under section 50 shall also be liable to be proceeded under section 174. In other words, apart from paying fine and 10,000 rupees a day, I am also liable to be proceeded under 174 of the penal code. Correct? Now, what does 174 of the penal code say?
You mean to say that the consequences are civil in nature?
Yes,
the consequences are the civil in nature.
No,
if you have not complied with that in the summons.
Yes. No, and also it is also criminal in nature because 174. If you see 174, whoever being legally bound to attend in person or by an agent to a certain place and time in obedience to a summons, notice, order or proclamation proceeding from any public servant legally competent as such public servant to issue the same, intentionally omits to attend at that place or time, or departs from the place where he is bound to attend before the time at which it is lawful for him to depart, such shall be punished with simple imprisonment for a term which may extend to 1 month or with fine which may extend to 500. So the consequence, I'm now taking a case where I willfully do not attend pursuant to the summons issued to me. What's the consequence? 174. That's in the PMLA itself. So how do you go down to the Code of Criminal Procedure? You can't. Now let's assume that I am an accused. I'm not talking about a person who is not an accused. Now let's assume I am an accused, because I can only be summoned in two capacities. Either as an accused or a person who is not an accused. Now, in that context, look at section 59. Now, the problem with 59, that this summons is to be issued by the court. So 63 deals with a summon issued by the ED. 59 deals with the summon issued by the court. Correct? Now, let's see what happens when a summon is issued by the court. But in this case, Manoj, that's not happened. Not in these proceedings. Now, what does it say? Where a special court in relation to an offence punishable under section 4, now, Manoj, I am sought to be prosecuted under section 3 and 4 of the PML. So, where a special court in relation to an offence punished under section 4 desires that a summons to an accused person or a warrant for arrest of an accused person or a summons to any person requiring him to attend and produce a document or other thing, or to produce a document or other thing, or to produce it, or a search warrant issued by it shall be served or executed in any place in any contracting state. It shall send such summons or warrant in duplicate in such form to such court, judge or magistrate through such authorities as the central government may by notification specify in this behalf, and that court, judge or magistrate, as the case may be, shall cause the same to be executed. So the scheme is very simple. If I am not in India, as your lordship knows, Malaj, no summons can be issued to a person who is not located in India. Because the jurisdiction of the court is circumscribed by the jurisdiction first of the police station, local police station, and an accused is outside the local police station within the territory of India.
What does the contracting state means?
Contracting state means where we have a treaty. Right? That treaty, Malaj, is the procedure to, and these are reciprocal obligations, Malaj, under the treaty, now, through which I can be extradited. So if I, for example, Malaj, I'm located outside India, I've committed an offence in India. What will happen is, Malaj, a summons will go, if it's a summons, it will go through the Home Ministry, and there is a memorandum which says what the procedure will be to be adopted. It will go through the Home Ministry. But Malaj, if I am an accused, and they are seeking my arrest, then it will go through the External Affairs Ministry. And it will be served through the mission wherever we are located. India has missions all over. And that mission through the court of appropriate jurisdiction will then serve me. And then I'll be served. And then I have to abide by the law. So therefore, when it comes to an accused and a court order of the special court under the PML, then Malaj, the procedure under the Code of Criminal Procedure is 105, but under PMLA it's 59. So if it's not an offence under the PMLA and it's an offence under the Code of Criminal Procedure, then 105 will apply. But since it's a PMLA offence, 59 applies. And those memorandums of the Government of India would be applicable as I presently show. So it says, it shall be served or executed at any place in any contracting state. It shall send such summons or warrant in duplicate in such form to such court or judge or magistrate through such authorities as the central government may by notification specify in this behalf, and that court, judge or magistrate, as the case may be, shall cause the same to be executed. Right, Bharat? Now, in the facts of this case, which are the admitted facts, I'm not in India. Correct? At the time when the summons was issued on the 1st of September, I was in Australia.
By what mode you have served the summons? Served with the summons?
Placed it at my
You
residence.
are not in India.
No, they placed it at my residence.
Vested at the residence.
At the residence. At the local residence. Knowing full well whether I'm not here. It can't be done.